concerned citizens request for the court to issue a writ. And in response, the court, Mason County Court District has filed a motion to dismiss. And are you Mr. Bricklin?
I am, Your Honor.
Oh.
Nice to meet you.
Good afternoon. And then here from the court?
Mike Schechter, Foster Pepper for the Port of Shelton. With me is Eric Glashenberg. Good morning. Representing Adage. Rick Haas, also representing Adage.
And Mr. House?
Yes, morning, Your Honor. Afternoon, Your Honor.
Good afternoon. All right, Mr. Bricklin, this is your request. Go ahead, sir.
Thank you, Your Honor. This case arises out of a decision by the port to sign a lease option with Adage to make land available to Adage for the construction of a massive incinerator on the port property. We have challenged that decision, the decision to enter into the lease option, on grounds that the port has not complied with the State Environmental Policy Act regulations, which require environmental impact statement to be prepared prior to a government agency taking a decision like that. And so we initiated this action, and this is not, while there's a lot of standard procedures in place for challenging subdivisions and building permits and other land use decisions like that, we have to fall back on more archaic forms of procedure when we're challenging something like a lease by a government agency. And so we initiated this through the writ of review process, which applies before there was an Administrative Procedures Act, before there was a Land Use Petition Act. This was the way the courts did business. And those somewhat ancient procedures still apply for some miscellaneous categories of land use decisions like this one. It's possible that this action also is reviewable pursuant to the Declaratory Judgment Act, and so we also pled that in the alternative. The mechanism for issuing in a writ of review proceeding, because they're not very common anymore, is if the petitioner files the petition, the court, if it agrees, issues the writ. The writ is essentially it's a directive to the agency to send its administrative record to the court to be reviewed. That's what the writ is. The writ is a directive to the agency to send the record to the court for review. Under the Administrative Procedures Act, we don't go through those formalities anymore, but you do under the old writ process. So if the writ issues, the record comes to the court, and then typically the way these actions proceed is the petitioner files a brief. It's much like an appellate process at that point. Petitioners file a brief, the respondents file a responding brief, we file a reply, and then there's an oral argument presented to the court, and the court reviews the administrative record and decides whether an error has been made or not. So that's the process we are in with the writ of review. And if the respondents recognize that we're properly in front of the court and this is the right mechanism, then the writ frequently issues without any objection. If the respondents think the lawsuit is untimely, there's a statute of limitations issue, or you don't have standing, or other procedural objections, then you end up with a hearing. And that's why we're here today, because in fact the respondents believe that there are two procedural reasons why the writ should not issue. One of those is they argue that we don't have standing, and the other is they argue that we should have, our pleadings should have characterized this as an independent cause of action under SEPA instead of as part of the writ of review process. And so let me address both of those issues. And I'll maybe deal with them in the reverse order that I just mentioned them. And this frankly is the flip side of their motion. So they've moved to dismiss the case on those two grounds. It's the flip side of saying that the writ should not issue for those two reasons. When you challenge a lease option, a government decision like this, the appropriate mechanism is, as I said a moment ago, a writ of review. Either what's characterized as a constitutional writ if it's a legislative matter, or a statutory writ if it's a quasi-judicial decision that's being reviewed. And the motion by the other side doesn't really argue otherwise. They have not contended that we've used the wrong mechanism for hailing them into court to review the lease option. There's not a word in their brief about that. Instead, what they've said is that underlying our attack on the lease option is a claim that they've followed the wrong procedures under SEPA. And they're saying that should have been pleaded as a separate cause of action. And in fact, that should have been your only cause of action. They're arguing that we should have pleaded only a cause of action under SEPA and nothing under the writ or declaratory judgment act. And they're simply wrong about that. If you've had a chance to review our memorandum, we've laid this out in some detail there. SEPA is the law that says you have to do environmental review in one form or another. And there's a section of law that talks about the judicial review process, and it says that if there's going to be judicial review of compliance with SEPA, it can't be undertaken in isolation. It has to be linked with review of a challenge to the underlying government action. We refer to these as, if you were to challenge SEPA not linked to an underlying action, we say that's an orphaned SEPA claim. You can't, as the agency goes through the mechanics of making a decision and leading up to the ultimate decision, whether to issue a permit or whether to approve a plat or whether to enter into a lease, it precedes that ultimate decision with various steps in the environmental review process. Figuring out who's the lead agency going to be, are we going to do an EIS? If we do an EIS, is this an adequate EIS? And so forth. And the statute, SEPA statute says you can't appeal those intermediate SEPA decisions when they are made. You have to wait until the underlying decision, whether it's a building permit or a lease, until that decision is made, and then you challenge that decision. And when you challenge that decision, then you bring with that decision, you link to that decision, you challenge that there was something the matter with how the environmental review was conducted. And this isn't case law, this is the statute says that. It shall be, the SEPA challenge shall be linked to the challenge to the underlying action. So here the underlying action is this lease option. And so we've challenged the lease option. The only way to challenge the lease option is through the writ or the DJA, and the port doesn't claim otherwise. And in that challenge to the lease, we have alleged that the reason the lease option's invalid is because they haven't followed correct SEPA procedures. That's exactly how you're supposed to do these actions. And we've cited in our memorandum more than half a dozen cases, and frankly, I could have cited 30 cases where the mechanism employed to raise a SEPA challenge when you have a decision like this, an underlying government agency decision like this, is by filing the writ or filing the DJA action, and as part of that action, allege that that the agency failed to comply with SEPA. That's the way it's done. The only case they've cited to suggest, the only cases they've cited that suggest otherwise, none of them say what they want the court to rule here. The Harris case was a case where a petitioner filed an action using a writ, and the court begins the decision by saying there is no direct review under SEPA. The petitioner has sought a writ of a constitutional writ or a statutory writ, and will examine whether they have the right to one of those, which is exactly what we did. And in that case, the court then went on to say that the petitioner there didn't have standing, so they ultimately didn't allow the case to proceed. But they didn't say that, which is what the court thinks this case says. The Harris court didn't say, you can't proceed because you didn't allege in your complaint a separate cause of action under SEPA. The court didn't say that at all. And what the court grabs on in that decision is later in the decision, that case makes reference to a sort of a secondary argument the petitioners made to try to save themselves. And they said, well, even if we don't have standing under the petition for writ of review or statutory constitutional writs, maybe there's a direct cause of action under SEPA. And the court said, well, even if there is, you don't have standing there either. But when the court, but that's the part of the decision that the court grabs onto and says, look, they refer to an independent cause of action under SEPA. And the court never held that there was one. In fact, that sentence is contrary to the first sentence of the opinion. The case that the Harris court cites for that didn't hold that either. That was the Grays Harbor County case. Another case, ironically, from the court's perspective, where a writ was used to obtain review of an agency action, and SEPA came up with the writ. The SEPA claims were argued as part of the writ action. There is not a single case in the 30 years of SEPA law in this state, and there have been hundreds of SEPA cases reported, not a single case where a court ever said you are not entitled to writ because you were supposed to have obtained a separate, proceeded as a separate cause of action under SEPA. There's just not a case to that effect. The two other cases they cite are equally off point. One of them, the Grandmaster case, was a case that I know well. It was my case, and it was not this situation. In that case, our clients were concerned that King County wasn't making a decision that they thought they should make, and so we attempted, instead of waiting for the final decision to be made, we brought a lawsuit early before the county made its final decision and tried to get judicial review before the final permit decision was made, and the court said, you can't do that. And our effort to get early review was rejected, and not too surprisingly, frankly. There's nothing in that decision where the court says anything to do with this situation where a writ is used and the court doesn't address anything remotely like this.